Greetings, ladies and gentlemen. Attorney Sharif Silmi. We are here to discuss a few things today. The biggest thing I want to talk about is the November Bulletin that has been released. The November State Department Bulletin has really shown some retrogression for those who are in the third category of the visa backlog. And we're going to kind of go over that today and see if we can make sense of this and what are some of the potential solutions that exist with regard to how we can make this situation a little bit better for you and for your families. So I'm just going to pull up the bulletin here for you so that you could see exactly what's going on. And if you have been paying attention to some of our previous broadcasts and videos, what I've mentioned many, many times is that you do not want to rely solely on the State Department visa bulletin as it relates to adjustment of status. Rather, you use the State Department visa bulletin page to maybe get your first indication of what's happening. And then if you're in the United States, you're waiting to file your green card, what you need to do is go to the uscis.gov visa bulletin info page. And that will take you to the actual page that gives you the precise dates with regard to adjustment of status. This is very important because you need to understand that USCIS at times will use the filing date that the State Department issues for the purposes of adjustment of status. And at other times, they will use the final action date. So rather than going and looking at the final action date automatically and maybe being disappointed, you need to look at the actual USCIS bulletin that reflects exactly what's going on, when to file your adjustment of status. So I'm going to just start by reviewing October. All right. So again, here's the State Department visa bulletin page. Under dates for filing, you see visit uscis.gov visa bulletin info in order to understand when you can adjust status. So when we click on that, that brings us over to the dates for filing for employment-based adjustment of status. Now, within those dates for filing employment-based adjustment of status, you find that the first category remains current for all countries, including India. Second category has gone, and this is October. So this is the present month, September 2018 for China, and July 8th, 2012 for India. Second category. Third category is Jan 8th, 2014. So I know many of you have done downgrades in order to file adjustment of status. And one of the things that we have been saying is when the USCIS and State Department understands the amount of downgrades that are taking place, you're going to have a swap. EB2 is going to actually become more advanced than EB3. And that is exactly what has happened in November. So let's look at the November Bulletin. So you probably have looked at the November Bulletin. And if you maybe looked at final action dates for the November Bulletin, then you're probably not properly informed. So final action dates for the November Bulletin apply to individuals who are outside of the United States and who are waiting to acquire an actual visa that will go in their passport so they can immigrate to the US. Individuals who are waiting to file their EB2 and are present in the United States, which makes up, 99% of the people interested in this issue, are not to look at this final action date for employment-based preference class. Rather, they need to go to the link that takes them to the USCIS page. Again, it's right here. So I hope everybody gets that message because we also shared that last time. I'm sharing it this time. I'll continue to share this information because the visa bulletin information is what you need to understand. The actual USCIS determination of what information they're going to use for the purposes of adjustment of status. So here, dates for filing employment-based adjustment of status, for November 2021, which is the second month of the fiscal year. First category remains current. Second category, Feb 2019 for China, that's an advancement. India, January 8th, 2013, EB2, that is an advancement. What was it in October? July 8th, 2012. So we went from July 8th, 2012, and now we are Jan 8, 2013. So that is a 6-month advancement that has taken place in the second category. That's the good news. Now, the bad news is the reason why second category advanced is not because they've adjusted status for people who are in the backlog. The reason why second category advanced is because people left the category and went to EB3. So you've downgraded from second category into EB3, and so many people have done this that the dates for adjustment of status for EB3 have now become 2012, retrogressed to 2012, and that is a terrible, terrible situation from January 2014, and it retrogressed all the way to January 2012, a 2-year retrogression in 1 month. That is a train wreck, folks. That is an absolute disaster. There's no other way I could put it. This is, something that we are really, really, upset that the situation has deteriorated as such. There was a lot of hope in, different aspects of legislation, but I think a lot of people have lost hope with those developments in terms of the way things are going. So just so you're aware, anybody that is paying attention for India, you're looking at January 2012 for EB3, and you're looking at January 2013 for EB2. So those of you who have downgraded from your EB2 to an EB3 and you filed for an adjustment of status, if your EB3 I-140 is already approved, technically you can actually have your employer file a new I-140 in EB2 category. And then once that is approved, you can do an interfiling note requesting that your case be, considered under EB2 again, rather than EB3. However, you might just want to it depends on your date. I mean, I guess if your date falls in between these two dates, then, that's certainly something that you're going to want to do. If it's doesn't really make a difference at this point because you're 2014, for example, you just might want to wait and see a little bit, but probably the EB2 will continue to advance better than the EB3. That's something I've been saying for a very, very long time. The other thing that I think is the elephant in the room is that EB1 remains current. And rather than downgrading to EB3, folks need to be thinking about upgrading to EB1 because that may be the only real path that exists at this point, particularly if you have a date that is, higher than, let's say, 2015, 2016, or more recent. So again, when we're looking at these options, we want to understand that there are really important ways for people who are business and technology contributors to take themselves out of the visa backlog and file their case within an EB1 self-petition. And we've proven that. We've done it many, many hundreds of times. And the most important thing that you need to consider when you are looking at this kind of process is analyze what your business contributions have been over the span of your career. So if you're in an IT related field, if you're in a engineering related field, technology, just generally speaking, then what you need to think about is what are the most important business related contributions that I have been involved in. That is the centerpiece of any successful EB1A case, because not only does the business related contribution relate to your status as having what's called an original contribution of major significance in the field, it is also very, very important and relevant to whether you perform in a critical role for an organization that has a distinguished reputation. Essentially, what happens is, let's just think about this. Those of you who are in technology or business-related professions, if you listen to the information that's out there in the public domain, it tells you that if you want to file an EB1A, you need to have publications and you need to go start authoring articles. Well, I don't think that the USCIS officers are dummies. Rather, they understand exactly what is going on. And if you are highlighting the fact that you have published an article in the past month or two prior to filing an EB1A case, they are going to sniff the weakness of your case before they even open the seal on the box. Rather, you need to focus and put all of your energy into the actual work that you do. The centerpiece of your EB1A needs to be based on what you have spent your life doing and your time and energy on. So again, many very, very highly qualified, high-performing individuals are out there. You're sitting in this visa backlog and you feel like there's no way out. Hopefully something happens. We're always optimistic people, but at the same time, you really, really ought to think about how we can start to develop a different narrative for you and how you can put yourself in a position to be successful. And one of the main ways that we have been doing this for a very, very long time now is through the EB1A classification by having laser focus on business related contributions. So on one hand, you prove that you're involved in it. You're proving the originality, that this is your work that you've undertaken. And on the second hand, you prove the significance of the work. And remember, if you're proving significance of work, it doesn't mean that you're proving significance of your own personality. So if one creates, for example, let's say I create an application for a banking tool, right? A banking tool that allows the users to maybe send money instantly or whatever the banking tool is. The question becomes, can you demonstrate that you are among those individuals, or you are the individual who created the application, right? That's the question. If the answer is yes, then we just need to prove it. How do you prove it? Well, you can prove it within the company. You don't need external folks to prove that you did something within an organization. So you can get a letter or a statement or some kind of evidence from within your company that certifies that you are responsible for creating a particular application or designing an application or something along those lines. Now, once you've done that, the question becomes, is the application that you created, is the application that you are responsible for significant? So measuring significance of the application that you created or designed, or the process that you designed, or the database that you designed, or the power plant that you designed, or the security protocols that you designed, is the significance of that technique or product or application or whatever it is the significance of major significance? Is it of major significance to your field? That's the question. Is it of major significance to the field? Does the significance rise to the level that it has transcended your organization? It's known outside of your company. And there are 4 ways to think about whether something is significant. The first is if it has made an impact on subsequent work in the field. If it has impacted other people's work, that means it is an indication of significance because other people have been influenced by your work. So I created a banking application and now another bank is reacting by replacing their application to meet the high level standard that my application, had, right? And the engineer that did it said, yeah, when, Sharif's application was made, it ignited something within us and it allowed us to look at our system in a different way. And we created our own application. You've influenced the work of others within your field, right? That's an indication of significance. The second indication is that you have widespread discussion about the work contribution that you have made or about the business related contribution that you have made. And again, this does not have to be about you. It could be about the contribution itself. What kind of evidence exists regarding the discussion about the contribution? So when the application was released, was there a blog post? Were there articles? Was there a press release? Was it compared? Was there a review? Is this discussed? Was it mentioned in conferences? Was it, something that is externally accessible and available? This is widespread discussion. And remember, it does not have to have your name in it. It doesn't have to be something that is about you. If your contribution is being discussed, then we connect it back to you as the person, right? How do we connect it back to you? Through the internal evidence, internal documented evidence that states that you are responsible for this particular contribution. So you have originality, and now we have significance, widespread discussion, and impact on subsequent work in the field. The other two factors have to do with economic impact. So, are there contracts, license agreements? Is there any kind of, for example, scale becomes an issue here? What is the scale of the project? Has it, so if you're creating a banking application for, Wells Fargo Bank, scale becomes relevant. If you're creating a solution for Walmart, scale becomes relevant. Then the fourth thing is whether there's government interest. If there's government interest in the particular contribution, then that is an indication of significance. Hello, everyone. I hope everyone is doing well. So these are the things that we are thinking about as it relates to business-related contributions, and really just understanding that those of you who are on a visa backlog and are, really just feel that there's not going to be any advancement, or if you are at a level where, you are high-performing Silicon Valley folks, people that are around the, DC, New York areas where you are, at the very highest level of the financial world, the technology world, the, different kinds of, government consulting firms. We need to talk, because you can get an EB1A approved so long as we can demonstrate important business related contributions that you are involved in. It's very, very important. And demonstrating the significance of those contributions, outside of the, that transcends the employer, that's outside of the company. It's not so much that you're made such a great contribution and everyone at the company knows about it. You got a award, great job. You've, done whatever, employee of the month. That's not going to get you an EB1A. You need to demonstrate that your contributions have transcended the organization, significant to the field. All right. So the way that you do this is you take what's called the right to claim. Whatever contribution that you've been involved in, we need to claim the contribution. And that contribution becomes yours. Then you are able to demonstrate that this is a basis for recognition within the field as being among the best and brightest. So that is how we are able to get so many people who have been waiting in this backlog forever approved through the EB1A category. It runs the gambit, but I think for right now, I'm definitely prioritizing folks where you have command a high salary, because that's an objective test, right? If you command a high salary, then that is an arm's length relationship. Nobody's going to overpay for someone, right? So if you can demonstrate, above let's say, and it could be true for somebody that's between 2 and 300,000, but especially true for someone who is above 350,000, 450,000. If you're above 450,000 on your W-2 and you have not had an attorney analyze your EB1A case, and you're in a visa backlog, and you actually want to have a green card, then you're making a tremendous oversight, and you really, really need to, contact us and make sure that we're able to help you, because that is a objective indication that you are among the very best within the field. So I hope that folks understand that and are empowered to act on their own behalf, because it doesn't look like anyone out there in the government or legislature is going to help you at this point. So I'm going to shift gears and talk a little bit about national interest waiver and how that might need to, that can apply and be helpful for folks who are in the present situation. And also it can help with the, situation for people who are not in a visa backlog, because if you're from a country besides India and China, every other country EB2 is current. So anybody that is not from India or China, or not chargeable to India or China, and that's based on birth, then you can use an EB2 national interest waiver in order to apply for a green card. So there's a question about how high it needs for salary. Excuse me. So regarding salary, the question is, how high does it need to be? Well, the answer is that it's relative, because you have to look at the statute. What does the statute say? It says that the individual ought to command a high salary in relation to their peers in the field. In relation to the peers in the field. So when you present your salary, then we need proof of income, of course. Then the next thing that we're looking at is, what is the comparative evidence? What are the peers in the field making? And, we can use our search, mechanisms. You can also use things like salary.com, paycheck.com. The pay scale is a pretty good one. And some of them even have a tool where you pay a certain amount and they'll run a full analytical report comparing your salary to others. And that's a great piece of evidence that you can include in your case. So these are the things that we're able to do and make sure. So there's not really a specific number for high salary. Just know that it's relative, and that includes geographic indication. So if, for example, you worked outside of the US, you compare yourself with people that worked in your country or your area where you worked. If you're working within a particular state, for example, if you're working in Arkansas, it's not going to be the same as working in California. So there's a relativity aspect and component to this that you want to pay attention to. Now, I just want to mention that national interest waiver may be a very important tool for some of you who are in the visa backlog. And of course, it's definitely a great tool for anyone who's not, because essentially, if you've downgraded to EB3 and you want to kind of stay in that EB3 line, you can actually have an EB2 national interest waiver done. And that way, if the EB2 advancement continues and your date becomes current in EB2, then you can adjust your status based on EB2 national interest waiver while keeping your existing EB3 in place. So that EB2 national interest waiver, it's a waiver from the permanent labor certification requirement. So you don't need an employer to sponsor your case. So you can self-petition for a national interest waiver, and that will allow you to have approval in 2 different categories. So this is a very, very good way that you can benefit for yourself and enable yourself to kind of have an all of the above option approach. Many people who come to us, actually, what we do is when we analyze your case, I'm thinking about what is the optimal situation and solution and kind of lay those options out. So sometimes an option is going to be to file both an EB1A and a national interest waiver EB2. So that may be the case for somebody who's in an EB3, but would have strong qualifications for either of those areas. So those are things to consider as well. I think I'll wrap it there. I just wanted to, let folks know that there always is hope. There's always, ways that we can use the system to your benefit. It's important right now that you take matters into your own hands and that you don't allow the system to crush you. There's extremely talented people, high earning people, successful people who are kind of giving up and leaving to third countries. Now, before you do that, make sure you contact us, allow us to give you a chance to at least know one way or another. Don't depend on what your friends say. Don't depend on what you've heard. Don't depend on forums. Depend on professionals who know exactly what they are doing and how to get you to where you need to go. So I just hope that everybody remains well, and we, will be with you again very, very soon. Take care. Peace out.